Mic check, mic check. Okay, now it's showing that the mic is working, but so it pops up green as I'm talking, and then it's gonna get a little further, and then there won't be no green. So I haven't done anything. I've just set it up. Now watch, somebody gonna be in the comments like, I can't hear you. And they got it on the lowest setting too, which is crazy because I got the mic on the highest setting. Fun, fun. What states are we from? What states are we from? All right, let me minimize that. Let me get my stuff set up. I'm going to talk about the law. The law. All right, let's go here. Let's go here. And then I will okay, YouTube. Later. Right. Let me share TikTok. All right, let me know if the sound isn't working on YouTube. Put it. Need an account to watch on TikTok. All right. Saturday stream. All right. Right. All right. Now let me pull up the Constitution Declaration, Bill of Rights. And then we're going to get me some comments going. What's up, everybody? What's up? What's up? What states are we from? Got Illinois in the house. Let's get the chat going. Chat, chat, what's up, chat. What the kids be saying. They'd be like, "What's up, chat? Welcome back to the video." Illinois on YouTube. That's what I'm talking about. Pull up. So we got that. What else do I have on that side? I have my notes. All right, all right, all right. Did y'all know? Okay, this is random and it doesn't, but they got this thing called a Jewish encyclopedia, right? This Jewish encyclopedia said, in order to avoid the unwelcome associations and connotations of the word, these people called Jews began in the 19th century to call themselves Hebrews and Israelites. So they said these people that called themselves Hebrews and Israelites were not actually Hebrews and Israelites. And that's from the official Jewish encyclopedia. Said, all right, let me pull up my stuff and then I'll get to talking. That was just a random fact. That was free. Money. Go to the Constitution. We're gonna talk and yap about the Constitution real quick. Um, YouTube, how do I sound? How do I sound? I think we might have they it's the weekend, they may not be working for real tonight, the bots. Uh, let me pull that up. Alright. Interpretation, interpretation, and the purpose of the Constitution. I go over this all the time, but, uh, the Apostle Peter said that I don't hesitate to remind you of these things often. He said, "We're gonna go over the basics all the time so that it is not up for debate, that you understand the basics." Let me see here. Let me get that. Let's see here. Get it. Proof. Perfect. We'll put that down there. And then we're gonna do part one, and then we're gonna do part two because that's not sure. We'll do that too. Interpretation, interpretation, interpretation. All right. We always pull that up. All right. So, um, the Constitution. What is the Constitution? What is the United States Constitution? There's a huge, 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 huge deception on the Constitution. Huge deception on the Constitution. We don't know anything about what we call American history anymore. And it's actually pretty sad. We I think they call it civics. We don't have any concepts of civics anymore. Um, in order to understand the purpose of government and law in America, we have to start with the Declaration of Independence. Why? That is the document that started the country. Does that make sense? They said, if you wanna know why things are supposed to be set up the way that they are, you have to start with the Declaration of Independence. If you wanna know what's going wrong with government and law in America, you have to go to the Declaration of Independence. If you wanna learn, if you're from and live or born in one of the original 13 states, then you have to go to the Declaration of Independence to see why either things are going really well or things are going really wrong. Declaration of Independence is an accusation. It is a declaration of why the 13 colonies in North America separated from Great Britain. And I know that seems overly simplistic, but we miss it every single day. Like, why would they even desire to separate from Great Britain? Okay, well, if you wanna know that, you should need to know that, you're gonna have to go to the Declaration of Independence, right? So they tell you, the Declaration of Independence is broken into 3 parts. First part is reasons why anyone would want to separate the government that they were under. That this isn't exclusive to us. They said anybody would do this given the circumstance that we're faced with. And as a result, this is why we're doing what we're doing. And they say, okay, well, We hold these truths to be self-evident, that all men are created, and we misinterpret the phrases in the Declaration of Independence. Some politician or somebody who is addicted to politics and gossip will love to twist the words in the Declaration of Independence to fit a commercial narrative. So they say, "We hold these truths to be self-evident that all men are equal and that all are endowed by their creator with certain unalienable rights. That among these are life, liberty, and the pursuit of happiness, and that to secure these rights, to secure what rights? Life, liberty, and the pursuit of happiness, governments are instituted among men." What is the purpose of government? The purpose of government is to secure rights. Somebody type that. Purpose of, you don't have to type the whole thing, just say secure rights. The purpose of government is to secure rights. That's what they said. They said, "What? Why do we have government at all anyway? What do we need it?" That's another topic for another day. But they said the purpose for government is to secure rights. That is the reason that governments are supposed to exist. They said that to secure these rights, governments are instituted among men, and the governments derive their power from the consent of the governed. And they said that whenever any form of government becomes destructive of those ends, what ends? Not securing rights. It, it becomes the right of the people to alter or to abolish it. That phrase is in the Texas Constitution today. They said they have the right, the people of Texas have the right to alter or to abolish government. That's a nasty term. Oh, I wonder what that means in the law dictionary. And they said the purpose of government is to secure rights. That when they stop securing rights, there's only one right thing to do, and that's to get to it, right? And so they said, okay, well, we're getting to it. And these are the reasons why we're getting to it. They said that the government does not obey laws. That was the first thing they said. Why are they separating from Great Britain? Because the government doesn't obey the laws of Great Britain. They said, "Let these facts be submitted to the world." They said, "This is the history of the king of Great." They say it. This is the history of the present king of Great Britain, which is a history of repeated injuries and usurpations. And they said, "He's established absolute tyranny." So they said, "To prove this, let these facts be submitted to a candid world." They said that he has refused his assent to laws, which is the wholesome and necessary, the most wholesome and necessary for. They said, "This is it. This is why we're doing it." They're gonna give you a whole list of stuff. He hadn't done this, he hadn't done this, he hadn't done this, he hadn't done this. Of all those things, he doesn't obey the law. He didn't have a problem with law. He said, "We had a problem when the government didn't obey it." They said, we're not against laws. We're not opposed to laws. We don't think we're above law. Somebody else thinks they're above laws. And that's become a problem for us because the purpose of government is to secure. So, what's the purpose of the Declaration of Independence? To let you know the reason why we're setting up this thing called the United States of America. The reason why colonies have now turned into states, and now that there is a new federal government called the United States, because governments don't obey law. All right? So, that's the Declaration of Independence. Now, let's use Virginia as an example, right? Virginia was the first company, the Virginia Corporation, all right? The Virginia colony came on the scene in 1607, right? From 1607 to 1776, Virginia had what was the law of Virginia? Not necessarily, no. From 1607, so this is before Virginia is a part of the this is a colony under Great Britain. Remember, like, nobody. I'm just saying the Declaration of Independence said that the King of Great Britain, the government, does not obey, right? So they had a law. What was their law? Their law was the common, right? They wanted it, they had no problems with it. Would I say it's perfect? Probably not, but that's what they wanted. They said I got Supreme Court cases that said, "Hey, these dudes weren't idiots. These people were educated. They were studied in law and history, different forms of government, and they said when it came time to set up the United States Constitution, they said you have to reference it with the common law," right? So this thing called Virginia comes on the scene. Oh, there go foolishness. There we go. Hey, we'll have a block party. So Virginia comes on the scene, and they say, "Hey, 1607 to 1776, we want the common law of England." They get to about 1750s, the early 1700s, and they if you study Virginia, they had a civil war in the 1660s. This thing called the common law of England. He said, "No, this is what the people want. These are our ancient principles, how we do life and government. It will be the law of," right? So from 1607 to 1776, these boys said, "The common law of England." Okay, 1776, at 1776, these guys said, "Okay, since the government isn't obeying the law that we like, that we want, that we use, then we're breaking off from Great Britain. And as a result of breaking off from Great Britain, we're gonna set up our own constitution in 1776, and we're gonna create this thing called a Declaration of Rights." Okay? So, and Joe, I don't know when, but in 1776, Virginia said, "Okay, we're no longer a part of Great Britain. We have our own constitution, and we have our own Declaration of Rights. This is what the government of Virginia is supposed to do. This is what it can and can't do. These are the things it's supposed to guarantee." And they have this thing called a Bill of Rights or a Declaration of Rights. Okay? So from 1776 until the federal constitution in 1787, Virginia has a law. And they said the reason we separate from Britain is because they were not obeying the common law of England. So they don't get on the other side of 1776 and say, "You know what? We don't like the common law of England." No, then they should have just stayed. They were already getting rid of the common law of England in Britain. right? So you don't get on the other side of 1776 and say, "No, we don't want a common law of England." No, they carried it over. They said, "When you read our state constitution, the Declaration of Rights, you have to go through the common law of England in order to understand what the phrases and the words and the system of government is to be implemented." They say you have to go to the common law of England to even understand our 3 branches of government. Does that make sense? So you get from 1607, this thing called Virginia, and they fight to get this common law. And then they get to a point where they say, all right, well, they're not obeying the common law, but we want the common law. So when Virginia declares independence, they say, bet, we want the common law of England. We get to bet. So they set up this government through this thing called a constitution, and then they give this thing called a Declaration of Rights, what we now know as a Bill of Rights. And you cannot understand the Virginia Constitution, as an example, or the Virginia Declaration of Rights without going to the common law of England. Does that make sense? So again, from 1607 to 1776, Virginia has had one law, and it has been the common law of England. The common law of England. Then you get from 1776 to 1787. This union of 13 states gathers together through representatives, and they create this thing called the United States Constitution. Okay, well, what is the law of the 13 states, right? Because 'Cause we're just using Virginia as an example, but you got, I don't remember, Massachusetts, Rhode Island, Maryland, uh, Virginia, North Carolina, South Carolina, Georgia, New Jersey. That's not 13 at all. Massachusetts, if I didn't say that. Okay, well, they all do the same thing. They said from we're just using Virginia because they're the oldest, from 1607 until 1787, when they get ready to create this federal constitution, which creates a federal government. They said, "Bet, how are we going to create this form of government?" They said, "Common law of England?" Sure, common law of England. Nobody debated it. Nobody disagreed with it. So when they set up these 3 branches of government, they said, "Bet, you won't be able to understand or comprehend these 3 branches of government without going to the common law of England." Why? Because we said in the Declaration of Independence that the reason we're separating from Great Britain is because the government does not obey the law. And what was their law? The common law of England, right? So you don't get on the other side of that, and they don't do common law no more. You don't get to 1787, and they don't do common law no more. Does that make sense? They never got rid of it. Does that make sense? It's the thing they've wanted from the beginning. Let me see if they turned off my mic on YouTube. Let's see. Where's it at? Mic check, mic check, mic check. No, they say it's still going, but I don't know if you can actually hear it on their end. But they don't get on the other side of 1776 and then set up a federal government in 1787 and get rid of the common law of England. They don't do it. So We get to the United States Supreme Court. What am I getting to? And I'm gonna get to it. So whenever you anybody talks about the United States Constitution or a state constitution, or they talk about law, or they talk about government, you cannot properly explain American law and American government without reference, without considering, without knowing the common law of England. So we asked the question, what was the object of the United States Constitution? And they said, the Supreme Court of the United States Supreme Court, that the object of the United States Constitution was to create 3 branches of government, right? Remember, this Constitution is not a new concept. 1776, Virginia had a constitution. Georgia, I don't think they got theirs till 1777, and I don't think New York got theirs till 1777 or 78. But before there was such thing as a United States Constitution, they had 13 constitutions. Well, they have. They didn't go anywhere. Does that make sense? When it came time to create this thing called the United States Constitution, they already had examples, they already had templates, they already had they said, "Alright, yeah, we're just gonna do it through this thing called a federal corporation. Whether you like it or not, I don't like it as much as I thought, but and when they set up this thing called the federal government and the federal corporation and the federal constitution, okay, they already had reference. They already had a Bill of Rights. They didn't even get the Bill of Rights in the federal constitution until 1791, but it was virtually irrelevant because each of the states out of the 13 states already had a Bill of Rights. In 1776, Virginia had a Bill of Rights. It was called the Declaration of Rights. Those right that is not changed. Since 1776, Virginia's Bill of Rights have not changed. Neither has any other of the original 13 states. So when they set up this federal government, they said, what was the purpose of establishing this federal constitution or the United States Constitution? It was to establish 3 departments of federal government: the legislative branch, the executive branch, the judicial branch. What was the purpose of the Constitution? To be honest, it was for international relations. It was for international relations. If they wanted to participate in commerce, they had to set it because and this is not the conversation I'm gonna have, but when you got 13 what they called sovereign and independent states, all bankrupt, they all got their own currencies, and under the Articles of Confederation, they didn't even have to obey the Congress that was set up at the time because they still don't, but that's a different topic. But they said when it comes to international relationships, we're creating 3 departments of government to deal with those things. They said the first was the legislative branch, which writes and creates statutes. Second one is the executive branch, what will be a international military, and, the presidency, and then the third is the judicial branch, which will, uh, enforce and expound or explain these federal statutes measured against this Constitution. Does that make sense? So what was the purpose of the United States Constitution? To create 3 branches of government for international relations. How does this new country relate to the world? started off pretty bad. They said, "All right, we gotta set up bankrupt, we ain't got nothing. We need a thing that can take loans and do all the things that international commerce allows them as this entity to do." Okay? So the United States Supreme Court said the purpose of the United States Constitution was not for Virginia. This is where I get in trouble. It was not for South Carolina. They said it was not for Massachusetts, New Jersey, or New York. The purpose of the United States Constitution was to establish 3 branches of federal government, and you cannot understand the restrictions placed on this federal government without going to the common law of England. I heard somebody say, "Okay, well, what is the Constitution?" They said it is a brief, means short explanation. It's 1 page of common law procedure. What is the Constitution? It is a brief, just a brief explanation of common law procedure. Well, how do you know that? Because you cannot understand the phrases and the sentences and the words in the United States Constitution going back to the common law of England, because that's how they wrote it. And I'm gonna prove all this to you, but I'm just giving you context. That the object of the Constitution, the United States Constitution, the Constitution's not fraud. Who told you it was fraud? Again, this is what happens when we don't understand the Constitution. They said the object of the Constitution was to create 3 departments of government, and that's what it did, and that's what it's for. They said Virginia had a constitution. Georgia has a constitution. New York has a constitution. They also have Bill of Rights. This is so fun. Let me go to something real quick. They got this thing, y'all can look it up. It's called the Kentucky Resolve. When the federal constitution got set up, Republican. Kentucky was beefing with Thomas Jefferson. They wrote Thomas Jefferson and said, "We're not okay with this. We're not okay with this United States Constitution thing. Do we have to follow this? Is this going to subject us?" Thomas Jefferson said, "No. The purpose of the federal constitution is for federal things." Said he said, "Kentucky got a constitution? Kentucky Kentucky got a Bill of Rights? Kentucky a Supreme Court? Kentucky got a trial by jury? Kentucky got a grand jury? Kentucky has the common law of England? Okay, then you should never have to worry about the United States Constitution." All right, so the United States Constitution, Article 4, Section 4 says that is not the Constitution. That is the Declaration of Independence. So this is what y'all love saying, right? This y'all favorite sentence in the United States Constitution. I hear this all the time, and people have no clue what it's about. People do not read the Constitution. They've never read it. So this is what Article 6, they say all debts contracted and engagements entered to before the adoption of this Constitution shall be as valid against this thing called the United States Corporation as under the Confederation. It said the Constitution shall be the supreme law of the land, and don't have no clue what that. Remember, I'm about to prove it. You cannot understand any phrase or words in this United States Constitution without going to the common law of England. There's not one phrase in the United States Constitution that can be interpreted or explained or defined without going to the common law of England. So when they say supreme law of the land, first of all, that word supreme is not even capitalized. They got law of the land, which is which is capitalized. Okay, well, where'd they get that phrase from? They got it from the Magna Carta. I talked about it yesterday for those who were on the live stream yesterday. What does law of the land mean? It means due process of law. What does due process of law mean? It means exactly what it meant in the Magna Carta of the year 1215. So again, you don't go to the United States Constitution and think you can explain it or understand it without going to the people who wrote it. So in Article 4, Section 4 of the United States Constitution, they say that well, I'll read most of it. It says that full faith, and this is Section 1 of Article 4, full faith and credit shall be given to each state to the public acts, records, and judicial proceedings of every other state. They said that in Section 4, the United States, this federal government, shall guarantee to every state in the Union a Republican form of government. First, actually, let me read before we even get there. Article 1, Section 8 says that Congress, the legislative branch, shall have the power to exercise exclusive legislation in all cases whatsoever over such district. So is what the federal government writes, does it apply to anywhere outside of such district? Because remember, y'all tell me all the time, this is the supreme law of the land. Okay, bet. I'm with it. So that means the exclusive legislation of Congress, whatever they write and call law, is only over such district. That's what it say. That's the supreme law of the land. Bet. You shouldn't have no disagreements with this constitution. They said this thing applies only over such district. And then they got a thing called parentheses. And in the parentheses, they say that it is not exceeding the 10 square. And they said if it does exceed the 10 miles square, then it is only by the consent of session by the legislator of the states. And if the state approves it, then that means it still only has effect over the things that are pertaining to such district. And then they tell you, okay, these are all things that we purchased with the consent of the legislator. So first they have to have purchased it in order for them to have authority over it. And then the operation that they're going to exercise this legislation has to be over forts that have been erected, magazines that have been erected, arsenals that have been erected, dockyards, and other needful buildings that they have lawfully erected. And then even those things that may be in your state only apply over such district. And this is the supreme law of the land. So if I ask you, do they write laws for Virginia? Do they write laws for Kentucky? Do they write laws for Massachusetts or California, New York, or Oklahoma? Remember, y'all told me this is the supreme law of the land, okay? We don't read it. So are they talking to the states? Or are they only talking to things that pertain to them? Okay, so we should have no issue with what the Constitution says because they're talking to themselves. And this is the supreme law of the land. So nobody should be like, "Oh, I knew we were still under Britain." You have no clue what you're talking about. Okay, don't say it's the supreme law of the land. See, this is where people try to debate me all the time. Well, federal law trumps state law. Well, federal law is not talking to the state. There's no such thing as federal law trumping state law. There's federal law and then there's state laws. We have to define law because they said the supreme law of the land is common law due process. And they reference that in Article 6 as talking to and for contracts previously engaged in. No, we the people doesn't mean the British men that wrote it. Remember, this is 1787. This is not 1776. And these are not British men. They are Virginians. They are Marylanders. They are Delawareans. They are North and South Carolinians. They declared independence from Britain. Britain acknowledged the sovereignty of the states in 1783. So you shouldn't even be paying attention to the United States Constitution because it's not talking to you. Why? They said it. When it comes time to write statutes, you're only talking to the things that they have authority over. You need to ask yourself that question because we make grand statements about the Constitution that we've never read. Let me see. It's so much. Let me see if I can find that one. All right, maybe I'll find it later. All right, so in Article 4, Section 4, again, it says that the feds shall guarantee to every a Republican form of government. What is a Republican form of government? A Republican form of government is one which the powers of sovereignty are vested in the people directly. And they cite two United States Supreme Court cases that explain this. They said by the Constitution, the United States Constitution, a Republican form of government is the right of the people. They said it is true that the United States guarantees to every state a Republican form of government. They said the guarantee is of a Republican form of government. They said that all the states had government when the Constitution was adopted. They said these governments, the Constitution did not change. This is the United States Supreme Court talking about a Republican form of government. They said when the United States Constitution got set up, it did nothing to the existing states. So when they declared independence from Great Britain, and Great Britain acknowledged the sovereignty of all the original 13 states, the United States Supreme Court said that all these states had governments when the United States Constitution was adopted. They said the Constitution did not change these governments. They were accepted precisely as they were. They said this after the Civil War. So why are you beefing with the United States Constitution that's not even talking to you? You live in one state. Why are you watching the news to wonder what the President Trump is doing? He's not talking to you. Why are you paying attention to the news that say, "Oh, they came out with a new law and this and that and that." They're not talking to you. They said when the Constitution is not this supreme law of the land that you're talking about is not even about you. No, every state already had bills of rights. Virginia in 1776 had a Bill of Rights. New Jersey had a Bill of Rights. New York, Bill of Rights. Georgia, Bill of Rights. They're not talking to anybody but themselves. They say, "Oh, but they got this thing called the United States citizen in the 14th Amendment." Okay, well, that was never talking to you. Why? Because the Constitution does not talk to the states. The states do their own things. This United States Constitution did not change the state governments or the state constitutions. They're never talking to you. Oh, well, what about the Civil War, the Reconstruction Act? Okay, well, again, the intention and purpose of the United States Constitution does not affect the states. No, they don't follow the Federal Bill of Rights. The Bill of Rights existed before there was such thing as the United States Constitution. All of the Bill of Rights come from the common law of England, which existed before there was such thing as the United States of America. And all the Bill of Rights come from the common law of England as they existed at the year 1607 when Virginia came on the scene. The United States Constitution is based on the original 13 states constitution. They say it. This is the United States Supreme Court after the Civil War. They said, okay, well, if you were born in a state, this thing is not talking to you. You have a constitution. You have a Bill of Rights. The states are sovereign after the Civil War. They said nothing changed. They said, this is it. They said, it is true, based on the United States Constitution, which is the supreme law of the land, that the United States guarantees to every state a Republican form of government. They said the guarantee is of a Republican form of government. They said all the states had governments when the Constitution was adopted. They said these governments, the Constitution did not change. They were accepted precisely as they were, right? I have some books that I found on the organic laws of the United States of America, and they are explaining that these original charters were uh, were part of the debates of setting up the United States Constitution and the original state constitutions. So they got this guy named Sir Walter Raleigh in the year 1584, and he says that the statutes, laws, I say it like it's two different. Yeah, they got this thing called statutes, then they got these things called laws, and then they got these things called ordinances. They say they're not all the same. They said the said statutes, laws, and ordinances are not to be against the true Christian faith. And the books that I'm reading from are after they're in the 1900s. They said the Charter of Maryland in 1632. They said the ordinances are to be consonant with reason and are not to be contrary or repugnant to the rights of our kingdom in England. Remember, this is the 1600s. So they said that the same ordinances do not in any sort extend to oblige, bind, charge, or take away any right or interest of any person or persons or of or member, life, freehold, goods, or chattels. They said, who is this? This is New Jersey. Well, this is in the 1600s, so I guess they had a West New Jersey and a East New Jersey. They said the common law or fundamental rights and privileges of West New Jersey cannot be altered by legislative authority. They said to make no laws, that this thing called the West New Jersey government is to make no law that contradict, differ, or vary from the common law or fundamental rights. They said this is all building up to. He said he liked my channel. Well, you won't be liking it much longer. Everybody say bye-bye. You see when the feds start showing up. The law of England thing. No, no, no. Everybody say bye. Everybody, they think they want to we can have a block party all day. So they said when it comes down to understanding the fundamentals of American law, they said they can't do anything that contradicts the law that they wanted after the Revolutionary War, at the time of the Declaration of Independence. So they said we can go all the way back to the 1676, we can go all the way back to 1632, we can go all the way back to 1584, and you will never get to a place where this legislative branch or the executive branch or the judicial branch has been given permission to do anything that is contrary to the rights that are secured in the common law of England. Does that make sense? They said these are the organic laws of the United States of America. He said, "We have no clue what you're talking about, bro." Supreme Court Justice Joseph Story said that it can hardly be doubted that the United States Constitution is predicated upon the existence of the common law. What did he say? They said it can hardly be doubted. They said this stuff is not up for debate. You don't have an opinion on this. You have nothing to add to the conversation. The conversation has been well settled that it can hardly be doubted that the United States Constitution is predicated upon the existence of the common law. If you don't know the significance of the common law, that's not our fault. They said this dude said, "This has not been denied by anybody who has maturely weighed the subject." So any scammer, any bot, any Fed, any attorney who thinks they can try to explain away the common law of England from the United States Constitution or the state constitution has not maturely weighed the subject, because they said it cannot be doubted. The United States Constitution or your state constitution cannot be predicated without the existence of the common law. They said this will abundantly appear on the slightest examination. You give it a little glance. Yeah, that's from the common law of England. That's how they put it in there. That's why they don't obey it. You understand? Why don't they obey the Constitution? There's nothing in the Constitution you should have a problem with. The issue that you complain about as it relates to government is them not obeying the Constitution. So you don't get to read the Constitution and say, "Oh, well, they're doing everything lawfully." No, they're ignoring and disobeying the Constitution. Does anybody get paid in gold and silver today? Okay, no, you don't. Why? Because they don't obey the United States Constitution, which cannot be explained without reference to the common law of England. Why? Because at common law, only gold and silver were considered money. They said, "Okay, well, you look at the Constitution even a little bit, and you will understand that this thing is all based on the common law of England." They said, "When the Constitution says the trial of all crimes shall be by jury, okay, well, this cannot be explained, or the mode of conduct of trials has to be given to the common law of England." So you don't even know what a trial by jury is if you don't go to the common law of England. They said, "You don't even know how to conduct a trial if you don't go to the common law of England, which is the law of the 50 states." They said that for the explanation of these terms in the United States Constitution, you have to go to the common law of England. This is not some random judge. This is Supreme Court Justice Joseph Story. He is credited with having the first dictionary attributed to defining the terms in the United States Constitution. They said, "Before we publish this dictionary, we need you to review it." And he reviewed it and approved it. He said, "Whenever you hear in the Constitution that judicial power shall extend to all cases in law," he says, "this is unexplainable." He says, "This is inexplicable without reference to the common law." He said, "What is a writ of habeas corpus?" He said, "Y'all didn't get that from nowhere else." He said, "You gotta go to the common law of England to furnish the true answer." He said, "Why? Because these boys in 1776 said that the King of Great Britain was not obeying the law." And they said, "We didn't have a problem with law." He said, "We had a problem with the government not obeying the law. So when we come to set up our laws, we're not getting rid of the common law of England." That's the thing we wanted. That's the thing we strapped up about. That's the thing we dropped bodies over, is that we wanted the common law of England. The government said they would obey the common law of England, and they didn't. And so we said, "Good." And so, uh, he says, "What is a writ of habeas corpus?" He said, "The common law, and that alone furnishes the true answer." He said, "The existence of the common law is not only supposed by the Constitution, but it is appealed to for the construction and the interpretation of its powers." They say you don't have any clue about the Constitution if you don't go to the common law. You got nothing to talk about either, because you're not in a position of maturity to understand what the Constitution is even about. You have no clue what you're talking about. They said the common law has to be appealed to. to understand the construction and interpretation of the powers in the United States Constitution. They said, you don't know what legislation of Congress can do or it can't do going to the common law of England. You don't know what a police officer or the military is supposed to or can and can't do without going to the common law of England. You don't know who the lawful judges are in this country without going to the common law of England, because that's the thing they wanted. He said, what are crimes and offenses against the United States? And again, recourse must be laid to the principles of the common law. They said we're supposed to resort to the rails of the common law to give them the interpretation. Remember, the United States Constitution is on one page, y'all. They said there's no way we can explain all this. It is a brief of common law procedure. This is just a little explanation on how to do government. You have to go to the common law of England to understand that. They said, what are crimes and offenses against the United States? Recourse must be laid to the principles of the common law. We resort to the rails of the common law to give them the interpretation. They said Congress has provided for the punishment of murder, manslaughter, perjury, but it has nowhere defined these crimes. Why? Because in order to define crimes in the United States Constitution, you have to go to the common law of England, because crime and common law has already been well defined. They didn't just come up with new phrases. They reached back in history to get an explanation of it. They said, let no doubt ever be entertained on trials. That for the explanation of trials in America, they must be sought and exclusively governed by the common law. That's a big word. Governed by the common law, you're subjected. If you take those to the United States Constitution, you're subjected to the common law of England. They said upon any other supposition, upon any other thought other than reading the Constitution in light and reference and understanding and explaining and defining the United States Constitution, then you give arbitrary pleasure to guys in black robes called magistrates, to an uncontrollable and undefined discretion. They say when you don't understand the common law of England, when you don't understand the definitions and interpretations and understand how the government is supposed to operate the common law of England, okay, well, this is what we're left with, complaining about how the courts disobeyed the government, or disobeyed the common law, disobeyed the Constitution, how they're taking away rights, how we always complain about how to get away with it, how to do it. Okay, this is what happens when we don't understand. They said, if you don't understand, if you don't go to the common law of England to understand how to restrain, how to govern, okay, well, then power will be left to the magistrates, to an uncontrollable and undefined discretion. They said, whatever may be the dread of the common law, the guys in the black robes will be way worse. They said, this is the thing we fought the Revolutionary War over. Restrictions on government through the common law of England. And anything outside of that will give the judges more power than they are supposed to have. They said there are a great variety of cases arising under the laws of the United States which regard judicial power. And the legislative will cannot be effectuated unless by the adoption of the common law. Does this make sense? Does anybody get this? They said nothing is more clear. The interpretation and exercise of the vested jurisdiction of the courts of the United States must be governed by the common law. Does that make sense? What state are you in? See, when we start explaining law, we got to go to the geographical location of where we're at to understand the law. They said this is not based on what you call yourself a United States 14th Amendment citizen. No, it's based on where you're domiciled. Because Article 1, Section 9 of the United States Constitution says, Section 8 says that the legislation of Congress only pertains over such district. So it's not based on what they think they can write and apply to everybody. It's based on where you're domiciled. Where are you domiciled? Because then I can tell you where the law is. See, if you drop me off in France, I know where the law is. The law is the Roman law. You drop me off in Italy, I know what the law is. It is the Roman law. If you drop me off in Nigeria, I have to know where the law is. The law in Nigeria, nobody would know. It's the common law of England. So if you live in Florida, what's the law of Florida? The common law of England is the law of Florida. Where do you find the common law of England in Florida? You know where you'll start? Florida Supreme Court cases. In Arizona too, the common law of England is the law of Arizona. 'Cause remember, they tell me all the time, "Well, the United States Constitution is the supreme law of the land." I bet. Well, you can't understand the United States Constitution without the common law of England. You can't understand your state constitution without the common law of England, which actually takes me to my next point. Good segue, everybody. Good segue. All right. So this is from another law book on constitutional law. They say you want to understand the Constitution? Let's talk about the Constitution. And then they don't talk about the Constitution. They talk about the common law of England. That's what's hilarious. This is the thing they don't talk about. They say Constitution as though it has no history of where they get the powers of government from. No, you know exactly where it comes from. We're supposed to know exactly where it comes from. Who set up the country? The original 13 states. Okay, well, why did they break off from their previous country? Because the government was not obeying the law. Well, what was the law? The common law of England was the law. Oh, when they set up the country, they don't get rid of the common law. They said, "No, this is the thing we wanted. This is the thing we strapped up about. This is the reason we fought a war, is so we could have the thing." And so you get on the other side, 1776 all the way to 1787, and they say, "All right, bet, we stuck to common law. It didn't go nowhere." Right? They said from 1607, you go to Virginia. They said, "Bet, we got a common law. We got a common law." All right, they get to 1776. We're all still good on the common law? All right, bet, we're still good on the common law. Right, you get 1787, you get this thing called the United States Constitution. We're all good on the common law? Bet. We're on the common law. You get to the 1800s, they're giving explanations on the Constitution. Yep, you gotta go to the common law. That's the only way you can explain, that's the only way you can understand it. Alright, so this is a law book on constitutional law, alright? They said the construction of the Constitution or constitutions must be construed with reference to the common law. Look, you can't see it, but it says the federal and state constitutions did not repudiate the established common law. They said this fact is taken into consideration by the courts in construing state constitutions. So when you read your state constitution, you should be saying, "Oh, yeah, that's from the common law of England. Oh, yeah, that's from the common law of England. Oh, yeah, they're not allowed to do that because in England back in the day, yada, yada, yada," right? That's how you're supposed to be seeing your state constitutions. So if I ask you what state you live in, and you say Florida, and I tell you some random black guy on the internet say, "Hey, the real law of Florida is the common law of England." Okay, well, you should be able to go to the Florida Constitution, right? Because Florida's not connected to England anymore, right? Or they were, and so you should be able to read the Constitution and say, "Yeah, yeah, that comes from England." They set it up so that the government wouldn't have power to take away people's life, liberty, property, without due process of law. Due process of law actually comes from the Magna Carta. You read the Magna Carta, they say you can't even be taken or imprisoned or put in handcuffs or have your property or anything. If they do it, they gotta pay you. That's why they say this thing called just compensation. You should be able to read your state constitution and find the common law of England and all the rights, all the restrictions on legislative power. They say, "Oh well, if he can take away rights, this doesn't apply to me," right? Because what's the purpose of government? The purpose of government, as explained in the Declaration of Independence, is to secure rights. So if they say that they can just take away something without due process of law, without a trial by jury, without a notice hearing, before I get to court, okay, well that doesn't apply to me because they've never been given power to do this. You can't understand the Arizona Constitution, the Illinois Constitution, the Florida Constitution, the Virginia Constitution without going to so they said the federal and state constitutions did not repudiate the established common law. They said we didn't create something new. They said this thing called the common law already existed. The Supreme Court of Tennessee, the Supreme Court of Florida said the common law actually comes from the scriptures. So we didn't create a new it may be a new country, but the law isn't new by any means. They say in regard to such cases, the courts of the state always regard the language in its common law sense. They said, "You wanna know the law? You won't find it in statutes, codes, regulations, ordinances. You have to read and define the words in reference to the common law of England." They said, "You don't even know the words in this thing without going to the common law." They said the common law of England was adopted by the several states. And they said when interpreting the federal constitution, recourse has to still be made to the common law of England. They said it has been said that without reference to this common law, the language of the federal constitution cannot even be understood. They said this is due to the fact that the instrument, the Constitution, and the plan of government created by the Constitution were founded on the common law as established in England at the time of revolution. They said, "You wanna know why things are supposed to be the way that they are? You gotta go to the Declaration of Independence." And they said that if anything that we're about to accuse King George III of has been happening, then you have the right to alter or to abolish. I don't wanna get in trouble, right? So they said the language of the federal constitution cannot even be understood without reference to the common law. You should be able to read your state constitution. Primarily, people say, "Well, which one?" Because I got multiple. You need to read all of them. Compare all of them. You gotta get out a pen and pad. Say, "No, you can't just Google and AI this stuff. You gotta get some homework." You might wanna leave TikTok for a couple months and get these books out and get to work. Yeah, this ain't no magical filling out fake pieces of paper. No, you got to do some homework. You got to be able to prove to a jury that you're telling the truth and the government's lying. Most people can't do that. They said, this is due to the fact that the Constitution and the plan of government on the common law as established in England. They said the Bill of Rights is taken exclusively from the common law and must be construed with reference to the latter. So you think you have a Second Amendment right, or you think you got the right of free speech, or okay, well, you got to be able to trace all that back to the England and show how they restricted the government from being able to take away those rights from you. You got to be able to prove that to a jury who stays on TikTok all day, who play video games all day, who's riddled with debt. You got to be able to prove that to them. No, your state has everything it needs. Your state constitution has everything it needs. You can just go from your state constitution straight to England, straight to the Magna Carta, or straight before the Magna Carta. There's not. So your state constitution will explain everything. You can use whatever state you're in. They're going to have multiple what they call revisions of their state constitution. So the constitution they may have came out with 10 years ago. Okay, well they've clearly written things that benefit them more than they benefit us. So you got to use. Okay, well you got to show me where you had permission to take away this right from me. Because let's take for instance, let's stay with Virginia, right? Virginia's easiest, they set the example for us. So Virginia's original constitution was in 1776. Okay, well, they may have a new not a new, but the latest revision of their Virginia state constitution, right? Okay, they never took away, they never, repealed the original constitution. Everything in the original constitutions of your states still, and they can show you one piece of paper where they got rid of it because it doesn't exist. They would have to rename the state. They would have to rename the country. You understand? So you could take your state constitution, the oldest, what, however many versions, you can buy them online. They're like 10, 15 bucks a pop. Okay, well, I'm gonna go for the Bill of Rights from, if you're from Virginia, hypothetically, from 1766, and then I'm gonna take the one that came out in 2007. We're going, right? So they said that without reference to this common law, the federal constitution cannot even be understood. They said the Bill of Rights is taken exclusively from the common law. They said specifically, the United States Supreme Court has taken the common law into consideration in construing the Fourth Amendment. This is the Supreme Court of Florida. They said it is not only proper but necessary that reference be made to the principles of the common law when ascertaining the meanings of the terms in a constitution. The Supreme Court of Ohio said that it is the common law that we must look to for the legal definitions and judicial ideas in interpreting the federal and state constitutions. Who is this? Pennsylvania. The Supreme Court of Pennsylvania said, well, you can actually look to state Supreme Court cases prior to the adoption of the United States Constitution for consideration, which I tell you, you can argue anything in front of a jury. You go before a guy in a black robe who's not the judge. Okay, well then he don't want to hear none of that stuff. Who are the lawful judges of your state? State constitution. Who is this? This is the Supreme Court of California. They said the common law of the Supreme Court of California said the common law formed the basis of almost every right secured and every remedy provided in the California Constitution. They said the federal Constitution is for federal things. If you're dealing with the feds, yep, you need to go to the federal Constitution. If you're dealing with state things, you just go to the common law of England. They say you just go bypass all that, right to England. Go right to the year 1250. You can go back further than that. You can go a little further if you want. But they said, okay, if you're dealing with federal things, you go to the federal Constitution. If you're dealing with state, you can just go straight to where they get this thing due process, where they say life, liberty, and property can't be taken without due process. Well, okay, well, that is explicitly verbatim from the Magna Carta in the year 1215. It's in every state constitution today. So you go right to the year 1215 and say bet. Why? Because they said every right secured by the Bill of Rights comes from the common law of England. That's why Virginia had a Bill of Rights. They all these cases say it. They say, yeah, well, technically the states have a Bill of Rights. All these Supreme Court cases, they say, well, if you're truly of the state, you wouldn't have needed to come to us. You could have got it done with just the common law of England. I don't want to get in trouble. I don't want to get in trouble. The Supreme Court of Georgia said that the common law and the English laws were adopted in this state. They said when we adopted the common law of England, we adopted it as an entire system. So if I ask you what the law of Georgia is, remember Georgia is one of the original 13. They said that in the 1900s. So if I ask you what's the law of Georgia, you can't say the Georgia Constitution. No, the Constitution just creates government. It's not the law. Law exists without government. That one. See, law existed without government. If you don't believe me, go read the book of Genesis. Before there was such thing as the Ten Commandments, they said that Abraham obeyed the law. What are you talking about? Moses hadn't come on the scene yet. They said technically they didn't have a government until King Saul came on the scene. If we're going to define government in a secular sense, they said the first 10 books of the Bible, they didn't have no government. They had a family. And since you can learn to live as a family and obey the voice and words and law of God, okay. They said the First Samuel says they gave a secular government to the people of God as judgment. And who were the judges in the first 10 books of the Bible? The book of Judges. They're all elders of the family. They're all one family. They're not random people. They're all part of that same family. The book of Hebrews says that Moses, when he had come to years, refused to be called the son of Pharaoh's daughter. Why? Because he chose to suffer reproach with the people of God than to endure the pleasures of sin for a season. You say, yeah, I'm taking off this Egyptian stuff. He said, no, I'd rather get in trouble. I'd rather lead a family and be under the voice and authority and laws of God, which they call natural law. That's what the Declaration of Independence says. It says the laws of nature and of nature's God. Supreme Court of Tennessee, Supreme Court of Florida said this common law thing comes from the scriptures. You know what they define the common law is? The unwritten law. They call it the lex non scripta. The lex non scripta. The unwritten law. Why? Because the Bible says he'll write the law on your heart. You see why they don't talk about the common law of England? Right? They make me look crazy. You can be a citizen one day, oh, super sovereign citizen. Oh, okay. Mhm. What these scammers talk about on TikTok all day, all filling out your magical paperwork. That's not the law. What's the law? Supreme Court of Georgia said we adopted the common law of England as an entire system. They say you want to learn the common law? You need to start in the year 510 BC. That's the first time the phrase common law was mentioned. You say you want to know the real common law? You're going to study after the resurrection of Christ. You're going to study these people called the Druids. And then about 300 AD, you're going to study these people called the Angles and the Saxons. And then you're going to study their history from about 300 AD all the way until the year 1066. And they said once you get to this guy called Edward the Confessor, that will be the completion of what they call the unwritten law. They say anything after William the Conqueror is not the unwritten law. I got books that say those people called the Angles and the Saxons trace their ancestry back to the people of Moses. Yeah, this law thing is nasty. That's why they don't talk about it. That's why they suppress it. That's why they act like they never heard of a common law. People tell me all the time, "Listen, they don't do common law no more." That's because he the one they talking about in the Declaration of Independence. Yeah, they don't want they all the accusations. Yeah, read it. They talking about them. They're the ones. I wouldn't talk about it either. These attorneys, they'll get it. They'll try to make me. All the Declaration of Independence isn't law. It's talking about you. That's why you don't want it to be law. You're the one they talking about in there. Denying people trial by juries, taxing people without their consent. Yeah, they talking about you. That's why I wouldn't want it to be law either. If I was the one that's on the other side of it. Yeah. Stop binding. That's what they say. Oh, the Declaration of ask it, call an attorney on Monday and be like, hey, they random black guy on the internet says the Declaration of Independence. No, it's not law. It's not law. Yeah, I bet it ain't. Because they talking about you. You the one that's in there. Yeah, I do it all the time. I prank call attorneys all the time. Hey, can you tell me what the definition? Where is an attorney in the Florida Constitution? Crickets. They ain't got no answer. They don't exist in law. Yeah, they don't like me. I get in trouble. Um, yeah, they said, uh, the Supreme Court of Georgia said English laws, the common law, we adopted this. This is our law. They said the Constitution is just creating government. That does nothing. It's not the law. They said when you get to the judicial branch, how are they going to apply these things? When you get before the jury, how are they supposed to apply these things? Okay, well, you have to go to the law in order to apply them in the court that the Constitution created. And they say you have to go to the common law of England. There's no other way for it to be considered law, for it to be considered lawful. Who is this? This is it. This is the United States Supreme Court. This is really what I've been trying to explain all night. They said the body of the Constitution must be read in light of the common law. They said the common law is the system from which our judicial ideas and legal definitions are derived. They said the language of the Constitution cannot be understood without reference to the common law. They said the interpretation, they said again, this is the same case. The interpretation of the Constitution of the United States framed in the language of the English common law and are to be read in light of its history. They said it's got to be interpreted like common law. They said the principles and history which familiarly to the framers of the Constitution. I think this is the Supreme Court of New York or I think it's New York. Let's see. It doesn't say. It's an old court. It's an old court. I think it's New York. We'll just say it's New York. They said these words, law of the land, which everybody try to quote, all the Constitution, bring law of the land. Okay, you don't know what law of the land is. These words, law of the land, mean by due course and process of law. Said this means by writ of the original or writ original of the common law. They said in this North Carolina. They said in North Carolina and Tennessee, based on the 29th chapter of the Magna Carta, this phrase, law of the land, has the exact same construction. Don't tell me the Constitution is the supreme law of the land, and then you completely disregard the common law of England where it came. Does that make sense? Uh, Here we go. I'm not going to read that. But I will write this. I will read this. The Supreme Court of Florida said under the basic rules of construction of statutory laws cannot impair rights given under a constitution. Does that make sense? They said under the basic rules of statutory construction is how they construct statutes, how they construct what they call laws, which are not laws. They said whatever we write cannot impair, take away, divulge of rights that were given in the Constitution. And you can't interpret the Constitution without what? The common law of England. Does that make sense? That makes pretty good sense. See, if I was an attorney, I could just lie and make up whatever they never cite the Supreme Court. They don't want you to do this. They say, well, actually, they always got a good lie to how they can try to explain away from it. How, well, actually, the Constitution is a living document, so that means that we can make it mean whatever we want it to mean. No, you can't do that. Nobody told you you can do that. You cannot understand the Constitution without going to England and the common law of England, which explicitly under a monarchy, you understand that? Under a king, these are things the King of England could not do. There's no way you get under here until we're free and all this stuff, and now you just magically have the powers to do it. Nobody told you you could do that. You took an oath to be bound by it, so there's nobody who told you you could do it. You understand that? They're gonna put this on CNN. Oh, he's going crazy. So they always got a lie. They got a lie ready to go. Oh, well, actually, he didn't go to our law school, so he doesn't understand. Right, right, right. They said the Constitution can be understood by anybody. That's what I was looking for. I can't find that case. Understood by the common man. Watch this. I found it. See, I'll be remembering this stuff. I ain't gonna find it in time. I promise they said it. I promise. They said the Constitution should be easily understood to the common man. They said you don't need Black's Law Dictionary. This is not what I'm looking for, but it's very good. Watch this. This is a guy named Calvin Coolidge to the Massachusetts State Senate in 1914. He said, "Men do not make laws." He said, "They discover laws. Laws must be justified by something more than the will of the majority. They must rest on the eternal foundation of righteousness." This that state is most fortunate in its forms of government, which has the aptest instruments for the discovery of law. I forgot I had this stuff. What states are we from? Since I can't find it, what states are we from? I'll prove it to you. So I'll ask you what state you're from. Now it doesn't matter if I can't find your state. I got most of them. What state are you from? I'll prove what law you got. Illinois. You sit down. Been standing up. Texas, Florida. Oh, here we go. Look, I got one of them sexy desks. This thing came from Walmart. Don't think I'm expensive or got money. Like $60 at Walmart. That look at that. South Carolina. Here we go. 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 He thinks he's fancy. No, it came from Walmart. It came from All right, what they say? Illinois. What's the law of Illinois, everybody? The answer is the same. We're gonna go to all these states, but the answer is the same. YouTube, is anybody live on YouTube? Can you hear me? They said no. They really be muting my stuff on YouTube, y'all. I'm not crazy. I'm not a conspiracy theorist. Illinois. Let me close the tabs. Got a lot of tabs. Got a lot of tabs. All right, what was that? They said the Supreme Court of Illinois that not until 40 years after the adoption of the Constitution. Mm, they said the legislator of Illinois has enacted the statute that the jury are the judges of the law and the facts. They said Illinois adopted the common law of England as it existed prior to the fourth year of James the First. When was that? 1607. They said the common law of England shall be the rule of decision and shall be considered as in full force. They said Illinois has adopted the common law of England in 2002. They said we've been had it. It ain't go nowhere. They said when Illinois became a state, they adopted the common law of England, and it is the rule of decision in all courts. So if they're not doing the common law, they are disobeying the law because that is the rule. What else? Somebody said Texas. What's the law of Texas? What's the law of Texas, everybody? It's the same as the law as Illinois. I found this the other day. They said that the Supreme Court of Texas said that all causes, civil and criminal, shall be tried by juries. They said, in the manner and form prescribed by this law. What law? This is right under Article 7 of the Texas Constitution, where they say that all trials shall be by jury and in criminal cases shall be regulated and conducted upon the principles of the common law of England. There you go. So if I ask you, what's the law of Texas? They said when we read the Texas Constitution, we cannot define crime or trial or judges without going to the common law of England. They said we got to go way, 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 way back. We got to start at 1215. You know how crazy that is? They said we got to go back in time. We got to get on the magic school bus to even understand what is written in the Constitution of Texas. And then they got a book. They say, okay, well, when Texas became a state, they said this is an act, or whatever they did before they became a state, an act to adopt the common law of England and to repeal certain Mexican laws. There you go. So what's the law of England? Or what's the law of Texas? I'm sorry. The common law of England. Actually, I have this in my book. I forgot about this. Texas said we adopted the common. I've been had this before I really even started studying the common law. Let me see. Let me see. Let me see. Let me see. Who's that? Oh, I got it. I got it. I got it. They said, because I was talking about admiralty law and equity law, and they said, no, we don't do no equity here. Dang it, where's it at? They said common law we adopted. I'm gonna find it. Sorry, everybody. No, no, no. Yep, there it is. It was in my face. They said the common law we adopted in this state, and it is the opposite of civil law rule. They said this is the opposite. Anything that's not a common law is the opposite of the law in Texas. This is some nasty stuff, y'all. They lie to us every day, talking about the common law. Oh, they don't do that no more. It was in old Britain. And okay, well, read the Declaration of Independence. They telling you. I seen a dude say, they say everything that happened in the Declaration of Independence is happening right now. So again, they say this is another case. This is from 2025. They said Texas adopted the common law of England on January 20th, 1840. And they said on March 16th, 1840. Oh, it took effect on March 16th, 1840. They said this thing called the common law of England is the legal basis, and it lies in the constitutional mandate of the Republic. Jurisdiction. What is jurisdiction? Jurisdiction is the power of the court to hear and decide a case. So the question is not about jurisdiction. The question is, how do they create a case? Because at common law, you have to have an injured party. They say the definition of a court, I got it in this book. People tell me all the time, well, a court is it's a bank. It's a bank. And the guy that sits on the bench, he's a banker. Okay, well, maybe that's not a court. Because the definition of a court is the person in suit of the sovereign. The Supreme Court of Georgia said at common law, in order to even go into court, there had to be an injury. So what's a common law court? A common law court is an injured party, a grand jury, and a trial by jury. And obviously somebody who is accused. So you got to put that in there too. So you got an injured party. You have the accused of committing the injured party, right? Because the right, whoever's been accused has a right to face their accuser, right? That's what the Constitution say. Bet. Well, at common law, okay, they got the injured party. The sheriff goes and gets the grand jury. The grand jury deliberates on whether, well, if it was an injured party, then they create the case. So if there was no injured party, then the grand jury would create the case. They would say a presentment of an indictment or a grand jury. But either way, the grand jury would be a part. They would create the indictment against the accused. The accused would be before the jury. The accused and the injured party would be before the jury. And then the jury would decide the law and the facts and give the verdict. And I believe the magistrate prescribes the punishment. But that would be a common law court. That would be the person in suit of the sovereign. Right? So how does a case get created where there's no injured party? How do you end up in front of a guy in a black robe where there's no injured party? It would be based on a contract. They say you can't even end up in court if they can't create a case. They said, what is jurisdiction? Jurisdiction is the power of the courts to hear a case. So people tell me all the time, brother, I'm just going to challenge jurisdiction. Nah. How did they create a case? How did they know who you were when there's no injured party? An injured party say, hey, all right, you got an eyewitness. You got somebody who's hurt, got their property damage. Okay, we got that part figured out. How did they know who you were if there was no injured party? How did the case get created? Because I got a million cases that say the judicial branch is not sovereign. The legislative branch is not sovereign. The executive branch, as contrary as the vice president of the United States may say, does not have absolute immunity when he violates the Constitution. So how did they know you existed? Right? That's the question we have to ask. So jurisdiction only is even a conversation if the case got created. How did the case get created? That's the question, everybody. Somebody type it. How did the case get created? How did they know it was me? What contract was created? Would that be the question? Kinda. If the case got created, a contract was established. The contract there, remember, this is that people tell me this is the United States corporation, right? Okay, so they operate based on commerce. How did the contract happen before the case got created? The case don't get created unless somebody believed there was a breach of a contract. So how was the contract created? So that weeks and months and years later, a case is created. Right? This is people love. Let's talk equity. How did the contract? How did they know who you were? What do you mean? What is this jurisdiction? That happens way, way, way later. You're not going to argue that you wouldn't be there if they didn't know who you were. How did they know who you were? How did they know that was your car? How did your car end up on their computer? Because the cop doesn't pay for the tow car, for the tow truck out of his pocket. Where'd he get the funds from? Who gave him permission to set aside funds to eventually maybe have to tow your car for a breach of a violation? What if you got snitched on? Well, it depends on the issue. What'd you get snitched on about? Right? So the answer is actually not the DMV. Remember, that's just how the case got created. But we want to go back before the case got created, because if this is a commercial court and this is a guy in a black robe and he's only in charge of fictions and contracts, right? Somebody told me the other day, well, what if I'm the fiduciary? Well, that's based on a trust, right? Well, a trust is a contract. Well, there has to be a meeting of the mind. People tell me that all the time, and then when I use it against them, they don't like it. There has to be a meeting of the mind. Somebody has to consent it, right? How did they know who you were? How did you end up on their computer that they could create a case? No, not birth certificate, not driving a car. How did they know who you were? No, guys, this is simple. This is simple. Nothing happened at your birth created a contract. A birth certificate is not admissible in court unless it has to do with health insurance. Now, sure, somebody said it, an ID, state ID. Is registering the car creating a contract? Nope. How you purchase the car creates the contract. So remember, the DMV happened way later. How, if you never went to the DMV, how would they know your car is or isn't registered? How how would it show up on the computer? How did they know your car exists? How did you purchase the car? Right? What is the proof of ownership of a car? And remember, I'm not your judge. I'm not your enemy. We just have to have this conversation. I had to look myself in the mirror and say, you know what? I went to the DMV and nobody told me to go to the DMV and ask for a state ID. Nobody told me. I didn't see one law that told me to do it. If I be honest, I need to blame my parents. I need to blame my siblings. I need to blame my cousins. They're the ones that brought this on me, hypothetically. Because if the law didn't tell me to go there, they didn't put it up on the billboard, say, hey, come get your driver's licenses. No, somebody took a bait. So how does the case get created? The case gets created by a contract, right? Okay, that contract happened when we went to the DMV and we said, hey, I would like a state ID. I would like a driver's license. And they said, okay, well, here's what we need. We need you to take a computer test. We need you to take a driving test. We need a photograph. We need to know proof of address. We need I'm sure in some states it may be a little different, so forgive me. But they say we may want a birth certificate. We may want it for the real ID, right? They're all fake. But we want a social security number. We need a zip code address. We need, you want to register to vote? Let's go ahead and knock that out. You want to register to vote? And then we need you to sign all these papers and then take a photo and then give us $100 and we will give you a state ID. We didn't ask one question. You said you want us to sign right here. You want us to take a computer test? They even sent a government employee to go watch you take the driving test. Yeah, we signed up to be employees. They didn't give us no. That lady at the DMV didn't give us no law. They said, okay, now here's the law on state IDs and driver's license. That never happened, did it? Nope. They say you asked for a state ID. You didn't ask for no other stuff. Right? You can recall, I'm guilty too. Every time I went to the DMV, I'm like, I didn't ask one question. You sign right here. Okay, I signed. Okay. So years, months, weeks later, some guy pulls me over, or whatever the issue is. And what does he ask for? Some guy claiming to be law enforcement says, all right, well, let me see the driver's license and registration. And I say, yes, sir. Here you go. Do you understand? And then he do, oh, okay, well, do you understand why I pulled you over? Yeah, no, whatever. It don't matter what he say after that. It don't matter what you say after that. You showed up on the computer, bro. The end. They said, yep, you gave us a social security number. You gave us a zip coded address. You gave us proof of address. You gave us a photograph. You took 2 tests. I don't know what you're complaining about here. And then we put this in our computer. And we gave you a nice little ID card. I see people, they make hoodies with their state IDs on them now. I said, bro, we're mega slaves now. And they say, here you go. All right. Well, don't complain when we pull you over, talking about you got rights and the common law of England. They don't want to hear none of that. Right to trap. No, we don't want to hear none of that. Yeah, we don't do that common law stuff here. Right? Then you get in front of the judge. Oh, Bill of Rights, Constitution. Nah, we don't want to hear none of that. You'll be held in contempt here. We'll let you sit for months, weeks before you get a trial or before you get an arraignment. So yeah, don't come talking that common law stuff. We want our Federal Reserve notes, or you shouldn't have been in here. Right? So how does a case get created? It gets created from a contract. What's the contract? The contract is we went to the DMV. The contract is we went to the dealership without asking any questions regarding the purchase. We didn't ask, okay, well, are you going to go to the DMV and give them the information on this car while I'm filling out a stack of papers that ain't got nothing to do with this car purchase? All right. And now they say they do everything at the dealership now. They say we want insurance right now. We want the driver's license right now. You can't even take it if it ain't registered. Why? Because they gotta make sure you're on that computer, baby. They didn't show you one law. They just said, oh, we can't give it to you. Call them. Call them. Will you give me the manufacturer certificate of origin if I pay for this car in cash? No, we won't. We give it to the DMV. Dun, 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 dun. So that was the territory. What was the territory? The territory was the paperwork. That was the jurisdiction. So we can't argue jurisdiction. What do we argue? Common law due process. But you can't argue that to the guy in the black robe because he's not the lawful judge. You say you want to talk law? Well, there's only one group of people you can talk to regarding the law in America. And that's the jury. And you better be competent enough to explain it to them. Does that make sense? All right. Well, I will be back here at like 6:30. I'm going to eat. 6:30 Central Time. I'll be back here at 6:30. All right.